Are you thinking about changing disability attorneys? Well, you can do so, but it's probably not a good idea, and I want to explain why. My name is Jonathan Ginsberg. I'm an active Social Security disability attorney. I'd like to help you navigate the confusing and, quite frankly, very frustrating aspects of Social Security disability law and to share with you what I know, what I've learned about winning disability cases. So, can you switch lawyers? Can you change lawyers in the middle of your case? Well, yes, you can. You have the right to change lawyers at any point in time. But I don't think it's a good idea. And there's several reasons for that. First of all, the reason many people give, and this is based on my experience when people call me and say, can you take over my case? I'm frustrated with my current lawyer. The number one reason they give is it's taking forever. It's taking a long time. And yes, it's true. Disability claims can take 2 to 3 years from the time you file until the time you get to a hearing. And that's a ridiculous amount of time. But that is not your lawyer's fault. The reason is Social Security does not have enough people. In fact, they have fewer people today, and I'm recording this in 2019, than they did 10 years ago. Literally fewer active employees, yet the amount of cases they're handling, the amount of claims for disability purposes has about doubled. So you've got a lot fewer people doing a lot more work. They don't have enough judges. Judges are backed up. In fact, they're making some changes where they're going to require video hearings now, and they're doing a lot more remote work. So it's just a lack of judges, a lack of support staff, a lack of personnel. That's why it takes so long. It is not your lawyer's fault. And even if you hear people say, well, the lawyer can request a dire need, or the lawyer can do that. All that's been done. Social Security is so backed up and so clogged up that there's really nothing anybody can do to expedite the process. And so to blame your lawyer is just not fair, number one. And number two, it doesn't serve any purpose because it's not the lawyer's fault. So if you're concerned about the amount of time, you certainly should reach out to your attorney, ask what they know, what they've been able to find out. But that's not a reason, in my view, to change lawyers. Now, the second reason people give for changing lawyers is they're not hearing from their attorney, that they make phone calls, they send emails, and they don't hear anything back. And I think that's a little more legitimate reason, because you do have a right to hear from your lawyer periodically to sort of know what his or her strategy is, what the status of the case is, and what's going on. Although, again, a lot of the information can be relayed through a paralegal, but I understand you want to hear your lawyer's voice periodically, and that's a legitimate concern. And I think if that's the problem, you need to get on the phone with the paralegal, the person, the gatekeeper, as it were, or write your lawyer a letter, an old-fashioned letter with a stamp, and say, I want to hear from you. I need to talk to you. Now, this is not something you shouldn't expect to talk to your lawyer every week, because, again, this is a 2 to 3 year process, and if your lawyer is spending every week talking to every client saying, I don't have anything to report to you, it's just taking forever, that's not a good use of anybody's time. But I think certainly every couple of months, 2 or 3 months, it's okay to hear from your lawyer, to get an email or a phone call, and to find out what's going on. And if you're not getting that, you should certainly ask and request that you be put on a calendar where you can chat with your attorney every once in a while, or certainly talk with his paralegal every once in a while to sort of know what's going on. If you're still not getting anywhere and you just made the decision, this is just not a good relationship here, I don't think the lawyer's got way too many cases, he's way too busy, or I get the feeling he's going to send a brand new associate to try my case without preparing me, then yes, you can change lawyers. But realize and beware of the problem with doing that. And that is that if you have 2 lawyers in the same case, and when I mean 2 lawyers who have filed the Form 1696, which is the Appointment of Representative form, if there are 2 of them from 2 separate lawyers in your file, Social Security will not approve a fee agreement for either lawyer. The fee agreement's where the lawyers get paid 25% of your past due benefits with a cap currently of $6,000. So if you have 2 1696 Appointment of Representative forms in the file, Social Security won't approve either one. Now, the first lawyer could withdraw and waive fees, and then the second lawyer's fee agreement would be approved. But if the first lawyer won't do that, and again, if the lawyer's put in 2 years of work and spent a lot of effort and time, I wouldn't blame him or her for not withdrawing and waiving fees. Then both lawyers have to file fee petitions. For you, that's bad, because in theory, the judge could approve both fee petitions, and you may end up paying more than 25% of your past due benefits to two different lawyers. You could lose half your past due benefits. Obviously not a good thing. Second thing, and this is more practical from the lawyer's end, Fee petitions are just awful. It takes forever. It can take an extra 2 to 3 years to get them approved because judges, again, don't have the time to deal with it. And so what ends up happening is you file your fee petition. I speak from experience. I file a fee petition. Nothing happens. I start calling. I start emailing. I keep getting the runaround. Oh, we're working on it. We're working on it. Meanwhile, 2-3 years goes by. I've spent a ton of my time trying to chase down this fee. It's taking forever. I just got to the point where if the first lawyer will not waive fees, I'm not taking the case. I'm not going to file fee petitions anymore. It's just not worth the hassle. So many lawyers feel the same way. So before you fire your first lawyer, talk to the second and get a second lawyer. Understand that whether the second lawyer is going to file a fee petition and whether the first lawyer will waive fees. And that's really the best way to do it, is to sit down with the first lawyer and say, look, this is not working out. It's not a good relationship. Will you withdraw and waive fees? Or if I can get the second lawyer to protect you for the amount of $1,000 or $1,500, will you agree to waive your fee? In that situation, I'd be more inclined to take the case. But again, if the first lawyer will not waive fees and will not withdraw his 1696, then I'm not going to take that case 9 times out of 10 because it's just too much of a hassle. And the third thing is realize that as an attorney, we're part of a community of lawyers in our jurisdiction. I'm in Atlanta, and the last thing I want is a reputation as an attorney who steals cases or poaches cases from other lawyers. There are a couple lawyers in town who do that. They'll just take a case without the courtesy of a phone call or trying to talk the client out of it. Everybody knows who they are. Nobody likes these people, and I don't want that reputation because, again, I'm part of a community of lawyers. I want to treat people the way I would like to be treated. So, again, I'm not going to just take somebody's case without first talking to that person, making sure that there's nothing that can be done to salvage the relationship, and then working out some deal on the fees where both attorneys get paid a reasonable amount for their work. So that's my feeling. Yes, you can change lawyers, but it's not a good thing to do. It's much better to make the right choice the first time around. Changing lawyers just creates all kind of hassle for everybody, and again, it may even limit the number of attorneys that would be willing to take your case, because like I said, if there's a fee petition involved, I'm probably not going to take it. I suspect that many of my colleagues feel the same way. So here you are, you've terminated lawyer number 1, you can't find a second lawyer who's any good to take your case because nobody wants to deal with the hassle with the fee petition. So that's why I would say be very, very careful. Try to work it out with your first lawyer, and just go with that and try to avoid having to change attorneys. Hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, and subscribe to our YouTube page and our Facebook page. Again, my name is Jonathan Ginsberg. I do wish you all the best. Thanks a lot.
Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.